Welcome to all of you. I'd like to thank all the members of the DILG DOJ Joint Committee for the review of the implementing rules and regulations of Republic Act number 10592, otherwise known as the GCTA Law, for the hard work that they put in to come up with an improved, revised IRR for this law, which we have seen to be quite deficient in terms of clarity and even on the matter of certain substantial provisions. All right, so as we speak, the Congress is in the process of making or proposing amendments to the GCTA law so that all the gaps will be filled and any ambiguities that have been recently discovered could be clarified. In the meantime, that Congress is doing precisely that. We are constrained with what we have right now, meaning the textual provisions of the existing law, and we have taken it upon ourselves to revise the implementing rules and regulations upon the basic assumption and position taken by the Department of Justice and supported by the Department of the Interior and Local Government about certain exceptions to the benefits of that law. That seems to be the bone of contention in all of these matters that have arisen during the past few weeks. So again, thank you to all the members of the Joint Committee. Later on, we'll brief you on the major features or the salient features of the revised IRR, and you may propound questions not only in connection with the revised IRR, but on any other relevant matter pertaining to this good conduct time allowance issue. So I will now turn over the floor to Secretary Anil of the Department of the Interior and Local Government for any opening remark that you may wish to say.
Thank you, Secretary Maynard Guevara. I'd like also to express my appreciation and gratitude to the review committee and the technical working group who really worked hard in order to come up with the revised implementing rules and regulations of the Republic Act number 10592. For the last 2 weeks, we have been beset with so many controversies and characterized by numerous Senate hearings that actually discovered some anomalous practice in the Bureau of Correctional. And the purpose of this revised implementing rules and regulations is we have now defined clearly the provisions of this IRR so as to prevent, again, this kind of anomalies and controversies. So with this, we believe, of course, the law will still be reviewed and amended by Congress, but for now, we can simply say that this IRR, revised IRR, shall be implemented and make sure that deserving PDLs shall be given the GCTA, and those who are not qualified shall not be given such privilege. So with this now, I think we have resolved a lot of issues and we can have peace of mind. Thank you.
Let me just give you a briefer on the salient points of the revised IRR that we signed this afternoon for your information before you throw any question pertaining to the matter. Number one, clarification on persons deprived of liberty or PDL who are disqualified from the benefits of the law. That's the first and foremost innovation of this IRR. A clear specification of the exclusions. And we enumerated these excluded types of PDLs from each and every time allowance granted under the GCTA law. For example, credit for preventive imprisonment or CPI. We enumerated the PDLs excluded, and you know all of this by now. Recidivists, habitual delinquents, escapees, and those charged with heinous crimes. All right, now when we go to good conduct time allowance proper, again, we reiterate these 4 classes of PDLs who are not qualified to enjoy the benefit of GCTA. All right, special allowance for study, teaching, and mentoring, or TASTM, which is actually a species of good conduct. All right, we identify at the expense or at the cost of being quite redundant the 4 classes of PDLs who are not qualified to avail themselves of this particular benefit, as well as for a special time allowance for loyalty or stall. We identify those who are not qualified for this particular benefit. Number 2, we defined in the revised IRR the meaning of heinous crimes. All right. So this definition partakes of 2 sources. One is the listing of heinous crimes appearing in Republic Act number 7659 or the death penalty law. All right, you will note that in that law, there is a particular class of offenses or crimes for which the death penalty is mandatorily imposed. No discretion on the part of the judge. All right, death penalty. So there is a listing of what these offenses are. Okay, and for purposes of the revised IRR, we identified that list. Okay, and the other source of definition will be from jurisprudence in the cases decided by the Supreme Court in certain heinous cases. Number 3, salient feature. We provided general guidelines for the Management Screening and Evaluation Committee, or what is known as MSEC. All right, so that is the committee within the Bucor and or within the BJMP that evaluates, screens, evaluates, and makes recommendations on the grant of GCTA and other time credits. All right, so what are these guidelines that we put in place? First and foremost, provisions on transparency. We provided for a rule requiring posting of the list of PDLs presumptively entitled to such credits and allowances, as well as posting in the respective websites of these agencies. And also participation by the Department of Justice, as well as accredited civil society organizations in the deliberations of the MSEC. Fourth major input in the new IRR pertains to the period for accrual and grant of good conduct time allowance and similar time allowances. All right. Now we provided that the grant will be made on the 2nd, on the 5th, on the 10th, and 11th years, and so forth and so on, of a PDL's detention. All right, so what does this mean? The assessment of good conduct will be done on a monthly basis because that's what the law says. All right, the time allowances are granted for each month of good conduct. But in this IRR, the actual grant will be upon accumulation on certain periods of time, as stated in the law, because nagvavary ang time credits depending on how long the person has been imprisoned. So after 2 years, so many number of days of good conduct time allowance, 20, all right, for each month, all right? when PDL has been incarcerated for, let's say, a period of 3 to 5 years, then at the end of, kung ganun ang period, all right, so the monthly time credit allowance will be a certain number of days, a greater number of days, like I think it's 22. Okay, so the grant will be at the end of such period, although the assessment is done on a monthly basis. Why is that so? Because of the concern or the comment na for a given month, a person will be given a good conduct time allowance. The following month, he commits an offense, nahulihan siya ng, let's say, ng shabu inside, so he won't get any time credit for that particular month. And then next month, he behaves again, all right, and he gets credit for that particular month, all right, after having committed a serious offense the previous month. All right, so to remove that anomaly, the grant will be done on a cumulative basis so that it's a general conduct of the PDL that will have to be taken into account. All right, so next feature of the new IRR is the non-extinction of criminal liability in case of grant to a disqualified PDL. All right, this clarifies the general rule that time allowances extinguish criminal liability. All right, so, but it will not benefit a disqualified PDL because such grant to a disqualified PDL is a nullity. So we make it clear that his criminal liability is not extinguished to any extent because of the grant of time allowances for which he is not qualified to receive in the beginning, in the first place. Lastly, transitory provision is clarified. Transitory provision that we put in there clarified the effect of the retroactivity rule. All right, of course you know that the Supreme Court rendered this ruling last June, making the grant of additional benefits under Republic Act number 109592 retroactive even to those who were incarcerated prior to 2013, the date of the passage of that law. So now we made it clear that if a PDL is disqualified but had been under preventive imprisonment or served sentence prior to the effectivity of RA 10592, lower time allowances under the RPC, Revised Penal Code, will continue to accrue. But a disqualified PDL placed under preventive suspension or convicted after effectivity of RA 10592 will not earn any such additional allowance. So I hope that is clear to you. So nung mag-take effect yung RA 10592, hindi na tatanggap ng kahit anong additional time allowances yung mga disqualified PDLs. But prior to the effectivity of this law, this disqualified, so-called disqualified PDLs will continue to receive the original good conduct time allowance granted to them under the revised penal code. Although mas maliliit lang yung time allowances granted under the revised penal code. All right, so those are the important things that the IRR of RA 10592 that we signed this afternoon made clear para sa implementation nitong Republic Act na ito on the GCTA. From here on, there will be no confusion and will follow exactly what the Congress intended to do, notwithstanding the many Okay, so having said that, we now open the floor to any questions that you may ask.
Before we finally open the floor for questions, we'd like to acknowledge the presence as well of Undersecretaries Echeverry and Malaya from the Department of the Interior and Local Government. Now, we open the floor for questions.
Following, sir, the revised IRR, the equipment, sir, process in GCTA.
Sir, we have Cecil from GMA7.
Cecil, ganito, no? Kasi yung joint committee ng DILG at saka ng DOJ was tasked to do actually two basic things. No? One is the revision of the IRR, and number two is the revision of the manual of operations. No? So ito yung nitty-gritty, no? To be followed hopefully uniformly by both the BJMP and Bucor. All right. So in fact, itong joint committee requested an extension of time to be able to come up with the revised manual of operations kasi ito yung nitty-gritty na no? So baka pati dito na rin lalabas yung requirement that before a person, PDL, is actually released on account of expiration of their sentence, whether by GCTA or otherwise, the approval of the SOJ will have to be obtained. No? So baka doon na rin papasok yan. But since we are talking about the details of implementation, the committee needs an additional period of time within which to do that. So going back to your question, to the extent that we can implement without having to come up with a very detailed operations manual, we will start processing. All right? But if we find it difficult without a uniform manual to actually start processing, then we may have to defer it until such time that clear operating manuals have been produced.
Kahit naman suspended yung GCTA releases, yung computation naman yan tuloy-tuloy pa din naman. Na mag-credit din later sa kanila kapag na-re-implement na uli natin.
Sir Leon from Rappler.
Follow-up lang, sir, paano yung case-to-case basis?
Like, for example, you can already grant the you know, it's really hard to say kasi may existing ano na no? May existing guidelines that need to be revised para ma-take into account itong revision sa IRR. So meron naman mga existing guidelines doon no on how to evaluate good conduct. So I guess that can be done, no? That can be done naman, although probably on a tentative basis, subject to any further revisions of the manuals that may be done. But we can, kasi sayang din yung time, and we are very concerned about those who need to be released now because they deserve it, but we cannot allow them to wait too long. So to whatever extent that we can implement, we will implement. Yes, Mike.
Does that mean, sir, that those who did not commit any heinous crimes, their GCPs can still be processed because that's not part of the aspect manual or the IR that's being revised? Is that correct?
As Secretary Anyo has stated, no, yung pag-credit ng kanilang time allowances will continue now, no? Especially hindi naman sila kasama doon sa 4 classes of PDLs na merong issue, no? So for those na talagang normal, ayos lang, ordinary prisoner, and they are complying with all the rules and regulations of the prison or the jail concerned, tuloy-tuloy lang yon yung pag-evaluate ng kanilang good conduct time allowance and so forth and so on until such time that they are eligible for actual release already. Well, depending on kung yung kanilang na-earn na good conduct time allowance is sufficient for them to be released on a reduced sentence because of the good conduct time allowance.
So we would expect na following this revised IRR, na meron na pong ipapublish na po sa website, the subsequent release po via the GCTA, ipapublicize na po. If we will proceed na po with the processing po of the early release of prisoners qualified under the GCTA, sir.
Yung sa details niyan, I cannot really answer how prepared, no, yung mga MIS divisions of the Bucor and the BJMP, no, at this time. But that is the intention, no. Yung posting in 3 conspicuous places, wala, madali lang yun, eh, no. Pero yung sa, uploading sa website, I am not sure whether at this time ay capable na ang MIS ng mga agencies concerned. But as soon as we are ready, as I said, we will implement, no? Kung alin yung kaya ng implement na, because we do not want to delay this.
Sir, is this still subject to 15-day publication po?
Yes, thank you for asking that question. That's part of the legal requirements that this revised IRR be published in at least 2 newspapers of general circulation, and in addition to that, be registered with the UP ONAR, Office of, what's the meaning of National Administrative Office?
Administrative Register.
Administrative, all right.
Owner.
Honor. All right. Okay. So that's part of the requirement. So we have to comply with that. 15 days.
Lian.
Kasi di ba the Bucor has already had batches that they slated to release bago masuspend. So can we assume na yung mga iba doon na hindi heinous crimes at clean na clean naman yung record, they can now be free pending the manual?
We don't see any legal obstacle para doon sa mga properly nakakuha na ng na-accumulate na. They're not disqualified under the rules. Walang issue, ha? Question. Point. Walang issue about the correctness or validity of the grant of their good conduct time allowance. If there are no issues pertaining to baka merong corruption involved or hindi totoo yan, and so forth and so on. Absent that, they should be able to earn the credit, and if necessary or the time allowance needed for their release has already been obtained, then there should be no reason why they should not be released immediately on account of an expired sentence.
Pag nakagawa, sir, ng violation on prison rules or another crime, on that month lang siya hindi mabibigyan ng GCTA. So parang mangyayari, sir, kasi di ba, 1 to 2 years, that's 20 days, that's 3 to 5 years, that's 23 days na GCTA. Parang mangyayari, sir, for the first 2 years na nakakulong, paano yun, sir? Accumulated na. So bibilangin, sir, yung each month na dapat siya ay credited for GCTA. Tapos pag nakagawa, sir, ng violation, paano yun, sir? Hindi na talaga siya bibigyan at all ng GCTA? For the first...
Yes, hindi. And for every succeeding reckoning point, no, ganun din ang theory, ang intention. But going back to your question, so paano yun? Kung halimbawa serious offense ang ginawa niya, prima facie, meron siyang involvement in a rumble, meron siyang nasaksak or something like that, no? So what will happen to any monthly GCTA na na-earn niya, no, before that incident happened? Well, it's something really for the guidelines, no, na masama. Kasi right now, we cannot input that in the IRR because that goes into the very operational aspect. Okay? So what we put here is the general legal framework of how to approach this issue. But as to how you will actually make that computation, we will leave that to the Joint Committee na magpe-prepare ng operating manuals, no? Yung manual for operations. Kasi doon na papasok yan. How do we go about making a computation of how much time credit we shall grant, considering na ito during this month, meron siya na puntos na ganito, but may nangyari na ganito, and so forth and so on. So how do we appreciate that holistically? All right, so that is something for the Joint Committee to, further study and come up with a solution.
Sir Benji from PNA.
You may ask any other questions not pertaining to the IRR, but pertaining to, everything that is related to what we're doing now.
Sir, pa-clarify lang kasi you mentioned that you still don't know when the MIS will be ready for publication. Publication of the names will be entitled to GCTA ba to? And what effect would this not readiness of the MIS have on dun sa 2,000 na, that would have been otherwise entitled nga kasi hindi naman sila heinous crimes offenders?
Well, for all we know, baka naman ready na eh. So I just said that because I don't have the info right before me now, no? But for all we know, Bucor and BJMP may actually have this kind of facilities, except that hindi pa lang sinasabi sa kanila na ganito ang gagawin nyo from now on. Okay, now as to those na you're talking about those 1,900 plus, all right, na release na, no? Okay, so what is your question regarding that? Wala na eh, na-release na sila, so there's no point in publishing pa or posting yung kanilang GCT at this time. Okay. They'll have to come back muna, no? They'll have to come back and we'll do a recomputation and reevaluation whether they are covered by the exclusions. So if they're not covered by the exclusions, then they should have no problem. Like for example, they were actually released because na-serve na nila talaga yung kanilang full sentence. At hindi naman sila recidivist, etc., etc. So they should not worry at all. O sila na-release, nasama doon sa listahan, pero granted pala ng executive clemency, or out on parole. So hindi sila dapat kasama doon sa listahan na yon. So they should have no problem. They just have to report back. Kasi nalista sila doon, explain what happened. Di naman kami na-release because of good conduct. We were released because the President grant us pardon. So hindi kayo kasama dyan, labas na uli kayo, alis na uli kayo. So we'll have to do that, but we have to go through that process.
One clarification po, sir, on the IRR.
Sir, yung mga heinous crime convict or charged with heinous crime, they can still earn GCTA, but under the revised penal code, the lower GCTA,
That's
sir.
correct. Oh, lower lang yung mga time credits doon.
5 days.
We cannot make this Republic Act or the GCTA law applicable retroactively if hindi po pwede yun because that will be to their disadvantage na wala pa naman yung batas na yan, hindi pa naman sila disqualified noon, and then sasabihin natin ngayon from now on you're disqualified. So prospectively pwede yun, from now on you're disqualified. Pero nung dati, hindi ka naman disqualified eh. Yung mga recidivists, hindi naman disqualified. So they earned time credits under the revised penal code. They keep that and will continue to earn that. Ang hindi lang nila ma-earn ngayon ay yung additional because of the GCTA law.
Yung mga future, sir, yung mga gagawa ng heinous crime in the future, saan, sir, sila? Under the old provision of the revised penal code? Or disqualified at all na po talaga?
Even under the revised penal code because of okay, even under the revised penal code. All right. The interpretation of the DOJ there is because of the disqualification, all right, created by RA 10592, all right, which applies prospectively in terms of disqualification. Then wala, hindi rin sila kasama ron.
So neither on the old RPC, they will not benefit, sir.
Yes.
Pero may pag-asa pa rin sila kasi may iba pa naman paraan para ma-release sila. Not through GCTA, presidential amnesty, pardon, parole, or siguro kung dumating na talaga yung 85 years old sila for humanitarian consideration, yun na yung mag-apply sa kanila.
Sir, dun ulit sa sinasabing you wanted to encourage kasi sustained behavior, hindi pwedeng on and off. Tapos you said the manual would clarify the computation. Ika-clarify din ba what kind of offense yung para Gets mo na, sir, mo.
Yes, oo, definitely. Kailangan may parang graduated yan eh. So depending on the kind of offense that was committed while imprisoned, no? So may may scale yan.
So, sir,
I would say.
at this level,
Depending
hindi niyo
on-
pa nadadefine?
No, hindi. That's why the joint committee needed extra time to be able to do that. Kasi talagang medyo mahirap-hirap na yun eh. What we're worried about is baka Congress will act so fast this time and come up with a new law. So, and they will ask us to do a new IRR based on a new law. So, etong pinagpapagura namin, I don't know to what extent they can still be used. No? But we're working on what is presently available. Yan ang batas sa ngayon. So we do what we need to do.
Hi, Sec.
Anjo, sir, from CNN.
Sir, the new IR also defined what heinous crimes are. Sir, may we know the breakdown of what types of crimes will fall under heinous crimes?
Nandun yan sa nandun
Walang
sa
additional.
death penalty law, qualified bribery, yung rape with homicide, mostly drugs related. Yes. Yan yung listed sa mismong death penalty law. Now, sabi nung iba, na-repeal na yan yung death penalty law. Ang position ng DOJ dyan, that was repealed to the extent only that the death penalty is now prohibited. Pero yung other parts of the death penalty law, which identified which offenses must carry mandatory death penalty, hindi ginagalaw yun. Alin yung offenses na punishable by reclusion perpetua to death? Alright? So, pwedeng heinous yon depending on the actual circumstances. Pwede rin hindi maging heinous depending on the factual circumstances. So, yung ganong classification of offenses under the death penalty law, hindi yon na-repeal noong 2006 nung i-prohibit ang imposition of the death penalty. Yun lang ang naapektuhan. Other parts of the death penalty law remain, like the classification of offenses.
Sir, walang dinagdag or binawas dun sa 7659?
Wala, yun pa rin. Kung ano yung listing na nandun,
Kasi sir, you mentioned
marami
about-
yun eh.
Kasi sir, you mentioned about jurisprudence eh. May diragdag ba about sa jurisprudence?
Yung sa jurisprudence, pareho pa rin. Odious, hateful, contrary to normal behavior of ordinary norms of decency, intrinsically evil. Yung mga ganong klase. Yeah. So, general description remains the same. All right, per jurisprudence.
Sir?
Apo, sir, tungkol naman, dun sa mga pinapasuko, sir, the basis, sir, kasi is the list provided by the Bucor. I think the list contains more than 2,000 names of heinous crime convict. Kaya lang, sir, we know for a fact na, as already revealed before the Senate investigation, na medyo magulo, sir, yung listahan because Janet Lim Napoles is included there. Rolito Go is also there, although Rolito Go is subject of a different court decision. Sir, paano yun, sir? Pinapasuko natin sila based on that magulong listahan, sir?
Yung listahan is 1,914. So yun naman ay isa-isang pinapag-aralan. Yung talaga namang hindi applicable, siyempre, hindi na yun, diba, kunyari, Napoles case, hindi naman yun hahanapin pa. But the order of the President is very clear. They were given 15 days to turn themselves in, and if they do not, then the PNP, the Bucor will arrest them. Yung nasa listahan na hindi na talaga dapat hanapin because of a special circumstance, hindi na kasama yun. But still that list is the basis.
Like Rolito Go, will he be arrested, sir? Can you say directly, sir, kung ano?
Hindi, ganito ha. The DOJ, of course, using Bucor corrected data, will come up with a cleanup list. All right, so reduced number, kasi nga aalisin yung mga hindi dapat nakasama. So we'll come up with that, no, and with pictures at that. with photos at that, before the deadline on September 19. Alright, para ito na yung cleaned up list o wala ka dito sa cleaned up list, you don't have to. Alright, kasi nga baka may nasama nga na hindi dapat eh. Admitted naman ng Bucor, yung head ng records nila, no, si Mr. Roque, na minadali nila, kaya nagkaroon ng daming errors doon sa listahan. So, we're coming up with a revised cleanup list before the 19th, with photos.
Sir, Johnson from DCMM.
Secretary, good afternoon. Sir, with the revised implementing rules and regulation, pwede ho ba nating pakalmahin ng pamilya Gomez, Sarmenta, and the Chongs of Cebu na talagang hindi makakalaya ang mga convicted PDLs po na nagawa ng krimen yung kanilang pamilya?
Are you referring to that particular case
Yeah.
mismo nila?
Apo.
Oh yes, certainly they will not. Because of the exclusion, no, yung heinous crime. Yung na-earn na nila, oo, kasi that was earned even prior to RA 10592 under the revised penal code. Kasi unang-una hindi naman death penalty yung sentensya sa kanila, hindi ba, wala naman death penalty. It's life imprisonment that we know in practice does not exceed 40 years. Now, they're not entitled to additional time allowances under this law, okay, but they earned good conduct time allowances before. Alright, so yun ang kanilang mapangahawakan, although kaunti lang yun, and some other ways maybe para makalaya rin in the future. But to say that makakalaya sila ngayon, hindi, malabo yun. Not under GCTA law. Yes, right. Yeah, under the old law, but not the additional. Only for the additional, huh? Only for the additional. Yes, yung under the time allowances under the revised penal code. Ayun, okay, yun yung i-clarify natin. Oo. Under the old law, they will continue to earn yung small time credits given. Okay. Alright? Kasi nga, itong GCTA law that excludes them provides the new additional expanded benefits. Itsipwera sila dun.
Sir, wait lang ha. Just to clarify it lang. Yung mga nakakulong, sir, before 2013, which includes Sanchez, they will continue to earn GCTA under the RTC.
Yes.
Yung mga nakakulong, sir, ng before 2013.
Hmm.
Pero yung mga makukulong, yung mga magko-commit ng heinous crime,
After,
the 2013
hindi na.
RTC law, neither
Yes.
they will not be credited with GCTA, sir.
Yes. Okay. Clear. Clear na tayo dun. Clear na. Ayan. Okay. Iba yung ano mo, yung premise mo doon sa kanya eh. Okay.
Sir, Bert from DWIZ.
Yes, Bert.
Ay, sir, ito lang. Yung, please clarify this one. Yung lumabas sa Senate hearing na GCTA for sale, saan papatak ngayon doon sa revised IRR?
Ano yung tanong mo, Bert?
Yung
yung
GCTA
for sale daw, for
Opo,
sale.
oo, for sale na GCTA. Paano po, paano tawag nito? Paano ngayon doon sa revised IRR, paano na nakita ito? O paano ginawa para yung for sale na yon is maiwasan na or either makita rin kung paano ginawa, sir, doon?
Yeah. Parang ibig, kasi meron niyang ano, hindi ba? Dito sa revised IRR, meron niyang kinreate, although na-create na rin to in the previous IRR, na committee, no? Yung Management Screening and Evaluation Committee. So, sila yung mag-evaluate every month kung nagbe-behave properly itong mga tao na ito. Itong mga PDLs, no? But if there is evidence to show na mukhang nagkalagayan lang dyan sa ibaba at marami naman nagsasabi na hindi naman nagbe-behave yan eh. In fact, tarantado yan and so forth and so on. So, doon sa committee level na yon, makikita kung dapat ngang bigyan ng good conduct time allowance or not. Kung halimbawa, sinasabi mo, bayaran lang yan eh, may pruweba na binayaran niya lang yung warden eh. Kaya siya binibigyan ng good conduct time allowance. Makikita dapat yon noong committee na kine-create natin under the revised IRR. Although nung dati, meron ng ganyan. So maybe now it's just the time to reorganize, pick the correct persons to man itong committee na ito. Yung hindi sila involved sa any anomaly sa actual na pagbibigay. No? Kasi that emanates from the warden. Eh. Yung sila ang nasa ground. Eh. Sila yung may direct contact doon sa PDL. Eh.
So once proven, sir, ano na rin sila, parang hindi na rin sila mapapagbigyan doon sa GCTA Law?
O syempre, kung hindi naman talaga karapat-dapat at kaya lang nire-recommend ng warden ay dahil nagkaroon ng bayaran dyan or what, wala ma-earn na ano yun, na time credit yun.
Sir, Nicole from GMA News Online.
Interpretation of the law does not exclude anyone or people convicted of heinous crime. Paano pag inargue niya, sir, na release siya lawfully at that time? Paano natin i-apply sa kanya yung parang hindi niya naman kasalanan na na-release siya? Paano po natin na-explain, sir?
If he challenges that in court, then of course the court will have to make the decision on that, no? But as far as the DOJ is concerned, if you were not entitled to begin with, even if you acted in good faith, hindi mo naman kasalanan yan. Kasalanan niya noong nagbigay sa'yo or nag-authorize sa'yo na lumabas. That's really beside the point. You have to go back and serve your full sentence. If you want to challenge that in court, hindi mo naman kasalanan, in good faith ako, yan ang interpretation ng let the court decide on it.
Sec, I'd like to ask additional guidelines on the ground po, itong pagpapabalik sa mga PDLs who were prematurely released. Because we receive reports that in some instances, it's the police going to the PDLs asking them to surrender. Is this part of a normal procedure? Can the police go to the house of a PDL who was released prematurely and say, you have to surrender, come with us to the police station? Is this considered normal? Or do police need warrants of arrest for them to do this?
Actually, hindi lang police yung aming binigyan ng memo dito, pati local government officials. We ask the local government officials, even the mayors, the barangay captains, to look at the list, and if there are personalities that are living within their constituency, then it is their obligation to inform these PDLs to come back. I mean, these released PDLs to return to the authorities. As of now, there are 612 na nag-surrender na, including kasama niyo sa Philippine National Police. So this is really helping them para, sabi nga, kung talaga namang qualified sila, makakawala din naman sila later. But kailangan talaga, maibalik muna natin sila lahat.
Sir, the reason why I'm asking, because there are cases decided by Supreme Court saying that if the police goes to a person without a warrant of arrest and invites him to the station, that can be considered a form of arrest. How do you intend to answer these if someone questions this in court, questions the supposed voluntary surrender?
Well, nasa word mo naman they were invited. So if they accept the invitation, then there's no violation there. Kung sinabi nating arrest yan, di binasahan niya ng Miranda rights. No? So, kung halimbawa ay hindi sila sumasama, okay lang din yon. But after 15 days, there's already an order from the President. We have to arrest them.
Hello. So sir, anong mangyayari on September 19 kapag nag-lapse na yung deadline and hindi pa kompleto yung nag-surrender, what will happen sa mga ayaw mag-surrender?
Well, unang-una, i-release na nga namin yung mga bagong listahan, no? So, alam mo na kung talagang kasama ka ron or hindi ka kasama. Alright, para doon sa talagang kasama, at talagang dapat na mag-turn themselves in after September 19, and they refuse to do so, okay, we have already taken this position na since under the law and under existing jurisprudence, you have not completed the service of your sentence, and it's your duty to serve it to the fullest. We gave you notice, we gave you a grace period of 15 days, you refuse without justifiable reason, then in effect, you are committing the offense of evasion of sentence. Because meron ka pang hindi nga natatapos na sa serve na sentensya. So there is reason, legal basis to have you arrested because that is a continuing offense. Each minute, each hour, each day that you refuse to turn yourselves in is a commission, is a continuing commission of an offense. And for that reason, law enforcement agencies may arrest you even without a warrant.
So, sir,
That is our
manhunt
position.
na-
If anyone is minded to challenge that, he may go to court and ask for any relief that he may wish to obtain from the court. But for now, that is how we intend to do it. And the Department of the Interior and Local Government, through the PNP, is ready to do so after the 19th.
Sorry. For guidance lang, sir, operational of effecting itong pagpapasurrender. We've been receiving reports that some of those arrested, for instance, in Iloilo, are to be taken to Mindoro. What's the proper procedure? Are they supposed to be taken to Bilibid, in Bucor, or are they also going to be taken to penal colonies in different parts
Well,
of the country?
the procedure is actually after the surrender, they were subjected to medical examination, and then they will be transported to the nearest Bucor institution. No? Kung halimbawa, kung sa Mindanao, malapit sa Davao Penal Colony, doon na sila ito turn over. And then let the Bucor consolidate them to wherever they are supposed to be disposed of. No?
Thank you, sir.
Out of curiosity, Secretary, are there any detention prisoners who were released under GTA, under BJMPs under the DILG?
Yes, BJMP kasi ay nag-grant din ng GCTA. But ang mga nakakulong kasi sa BJMP ay only 3 years and below, no? Prison correctional lang. So ano lang 'yun 3 years and below. So walang masyadong problema. Pagka normally kapag naman kasi more than 3 years, tina-turn over namin sa Bucor, doon na papasok yung GCTA computation niya.
Sir, with the Bucor legal chief in confinement at the Senate, is the Bucor fully equipped to face possible lawsuits that will arise from... Kasi baka may mga prisoner na magkaso na, baka bahain ng kung ano-anong petition ng Bucor. Are they fully equipped to handle these?
The Office of the Solicitor General will take care of that.